There's a phone number that ends in 8883. Can you please unmute your device and tell us your first and last name? It's *6 to unmute. Hit star and 6 to unmute the device. 8883. Please hit *6 to unmute your device. We can't call your case if we don't know who you are.
Hello?
Yes, please tell me your first and last name.
Well, my name is Benjamin Meyer, Meyer, unlike the paperwork that I've been sent. But it says Meyer. It is not me. I am here under duress.
Mr. Meyer?
Yes, ma'am. Meyer, not
Please
the person you have
talking,
spelled on this paper.
Mr. Meyer, please stop talking.
Yes.
The court will call the case of the state of Michigan versus Benjamin Meyer, case number DIB 053809. Is that correct?
See what's for the people.
267659. Thank you. Mr. Meyer, you've placed your name on the record a number of times at this point. You're here for a contempt hearing today. Mr. Meyer, you owe this court $168. When do you plan to pay it?
I do not plan to pay it because I don't own it. Period. End of discussion.
Okay. Well, then what I'm going to do, Mr. Meyer, is find you in contempt of court.
And what you're going to do is find yourself in a 1984 federal lawsuit.
All right. Let's do it however you want to do it. You're found in contempt. You need to be here in person.
Absolutely not.
Welcome back, everyone, and buckle up, because today's courtroom lineup is one of the wildest we've ever covered. We've got 3 different cases, each starring an individual who apparently woke up, chose chaos, and then dialed directly into a judge's courtroom to deliver it. We open with a man who can't unmute his phone, but has no problem unleashing a full constitutional meltdown the moment he does. His name is Benjamin Meyer, or as he claims, Meyer, spelled correctly, unlike the paperwork. And trust me, that small clerical gripe is nothing compared to the avalanche of accusations, threats, and insults he's about to unload on this judge. We're talking federal lawsuits, conspiracy allegations, and an actual, literal threat of a gunfight on the side of the road. Yes, he said that. Out loud. On record, but that's only Act 1. Act 2 brings us a sovereign citizen who believes child support laws don't apply to him because, wait for it, he didn't contract with the court. He also claims he made his kids in private, so he'll raise them in private, which may be the most unintentionally hilarious argument ever made before a judge. And for Act 3, we wrap things up with a traffic infraction case where the defendant claims he wasn't driving despite being caught on dashcam. Because of course he does. By the end of this episode, we'll have witnessed contempt charges, escalating threats, sovereign citizen mythology, a judge who somehow keeps her composure, and defendants who clearly didn't rehearse their courtrooms.
Right.
This fine and fee was paid 10 years ago or more. Now you can either fucking listen or we can do this out in front of your court.
Mr.
This
Meyer?
fine was paid 10 years ago. Will not be paid again. You fucking damn near shot me and killed me. Are you fucking kidding me? Have you goddamn lost your fucking minds?
30 days in the Washtenaw County Jail. Keep it up. We'll go with more.
And we'll see you hung in front of Washtenaw County Jail.
All right. Threats. I'm going to report that to the Attorney General.
I'm reporting you to the fucking Attorney General. Are you fucking nuts?
Okay. Everything you're saying is being recorded.
You are a goddamn tyrant.
All right.
I called the goddamn fucking attorney's office and you fuckers rejected me. Are you insane?
3 days in the Washtenaw County Jail. Keep it up.
Oh, you'll find yourself in prison, bitch.
All right.
You think you're a goddamn king? You're a fucking tyrant.
90 days in the Washtenaw County Jail.
Below me, bitch.
Seeing a classic maneuver, when someone knows the hearing isn't going to go their way, they immediately challenge the paperwork, the name spelling, the process, the temperature of the Zoom call, anything to invalidate the proceeding before it even starts. Benjamin's insistence that a minor typo magically nullifies the entire case is a textbook sovereign-style tactic. But the judge isn't biting. Notice how she calmly confirms he's present, places his name on the record multiple times, and moves forward. That's because in court, identity is established by acknowledgement, not by how the defendant wishes his name to appear on a fantasy birth certificate. And remember, the louder he gets about being under duress, the more obvious it becomes that the only pressure he's under is the pressure of consequences.
Yes.
He does not want to deal with me because he does not have a contract with 4D, with any 4D workers, so he doesn't want really to talk to me. He wouldn't talk about the motion, so I'm going to submit a recommendation that the motion be denied.
Okay.
Okay,
It's not
he's very
really
difficult. I know that you read through all the paperwork. He is the individual that was talking about how he has continued to talk about that he's, he has all these constitutional rights, and he's I don't know. I can't even explain what it is he's trying to get to or what he's trying to talk about. So
Okay.
So there's not much I can do. He just basically told me that I'm not someone that he's willing to talk to because he doesn't have
Okay.
a contract with me.
He maybe doesn't want to talk with me either, but you can get Sarah, you can bring him in. And
I can
we'll
get
address
him.
that.
Yeah, and
Thank you.
so I'm in the process of sending you the recommendation that the motion is denied, but I can go and get him, bring him in.
Thank you. Thank you.
Thanks.
A motion of the defendant, Father David Smith Jr., to modify custody and parenting time. This hearing is being conducted via Zoom. Present is Sherry Zorn, as well as David Smith Jr. Mr. Smith, it is now 9 o'clock and you are before Judge Brownick. Good morning.
Sir, I can barely hear you. I was in my vehicle where I could, and fortunately, we're back in front of Title 40 incentivization. If you can give me a second so I can make it back out to my vehicle so I could hear you, I would appreciate it.
Okay. Do you want to zoom back in then?
I'm parked right outside the door. Give me 60 seconds. I
Okay,
had
if
to
you wanna
come
hang
back
up and you can-
inside because whatever just went on.
Mr. Smith, your current parenting time is alternating weekends, Friday at 5 till Sunday at 7 with your 2 children. Is that correct?
Yeah, but we work outside of the order. I mean, I got numerous evidence that we do work outside of the order. That was arbitrarily done to maximize the dollar amount pursuant to Title 4D.
Well, that's wonderful that you can both be flexible about parenting time with your
That
work
is.
schedules and the children. That's once we work together. I'm just noting that the last order of the court, August 2015, so I do review these files in advance. I review your motions. I review the past orders. I review the history of the case, Mr. Smith.
I appreciate that.
So I'm just noting that the last order gave you specific parenting time, alternate weekends, Fridays at 5 to 7 at 7, Sunday at 7, and you could have additional parenting time, but that's what your absolute minimum. Now, in your motion, you're asking for an 80-20 split pursuant to your 14th Amendment to the U.S. Constitution. I don't know. This is not a constitutional issue. It's a state law issue, Mr. Smith. And in order for, first of all, have you talked with Ms. Zorn this morning? Do the two of you have an agreement? Certainly, if you have an agreement, you know what's best for your 2 children.
Sir,
We do not.
am I
Okay. So is there any merit in talking, Ms. Zorn and Mr. Smith?
And here it is, the moment the hearing officially transforms into a courtroom disaster. Mr. Meyer is already skating on thin ice by openly refusing to pay, openly refusing to appear in person, and openly disrespecting the court. But the instant he threatens the judge with a 1984 federal lawsuit, he signals he's more interested in theatrics than resolution. This is where judges typically clamp down, because a contempt hearing isn't a debate. It's a check-in to determine compliance, and he's loudly announcing that he won't comply with anything. By escalating in tone, language, and hostility, he actually forces the judge to escalate her sanctions. Contempt isn't emotional. It's procedural. And right here, he's writing his own jail sentence, one sentence.
So you're innocent, but there's no criminal charges here, so I'm not sure what you're innocent of.
But-
Mr. Smith, no one's accusing you of anything. I'm just asking, normally the two
Exactly.
parents will talk, and maybe they come to their own agreement. but that apparently is
I
not to be
want
possible this
50-50.
morning.
This is a
So you're asking
non-TANF
for-
case getting treated as a TANF matter. I want split custody, mutual agreement, all Title 4D insignification cease and desist immediately. I will be sending letters out today to all parties that touch this case negatively, and I'm pursuing charges 42 U.S.C. 1983 and Article 3 corporate deprivation of rights. This is arbitrarily done underneath color law. I do not consent. I have not contracted with Title 4D. I would submit into the court's blessing versus Freestone, Wehunt versus Ledbetter, sir. I don't presume ignorance on the court behalf today. Therefore, I'm left to believe something much more sinister is going on here.
Right, Mr. Smith, under it's not a constitution, under state law, Michigan law, there
I
must
do not
be.
acquiesce to state law, sir. I operate on federal law only. This
Okay.
is impeding my rights. I am going to transfer it to Article 3 court and pursue. I'm going to file an emergency injunction if I can't even make my bills. Due process has been violated. Fair Creditors Act of 1970, you guys are taking well over half of my check. I can't even make my bill. This forces me into my 13th Amendment, which is enslavement. Pursuant to no lawful money, this is a bill of pen and penalty underneath Article 1, Section 16 of the Constitution, sir. I do not consent. I do not consent.
This is the point where the situation stops being disrespectful and becomes downright dangerous. Listen closely, he threatens gun violence, claims the court almost shot him years ago, accuses officials of tyranny, and promises to see the judge hung. These aren't just outbursts, they're explicit threats on a recorded court proceeding, which can, and often do, lead to criminal charges independent of the original case. Judges rarely raise their voices during moments like these. Instead, they meticulously document everything said, because every word becomes evidence. When she says she's reporting the threat, she means it. And the defendant, instead of recognizing the seriousness, doubles down, convinced that volume equals victory. It never does.
To follow, there must be a change of circumstances that would
Must
support
be
a
an
modification of custody and parenting time. In your motion, you've not alleged any change of circumstances that would warrant a review of custody and parenting time. So with all due respect, the court at this time will deny
Sir,
your motion to change custody and or parenting time.
I have the right to my privacy. I can't even make my bills with what you guys have done here today. I can't, honestly, I have proof. I would like to submit into the court's Exhibit A if there is no objection. I have a pay stub right here. I work 58 hours a week at $30 an hour. I come home with less than $300. I can't even make my bills.
That's an issue of child support, Mr. Smith. You're asking to modify custody and parenting time today.
I am
If you
not
modify
here. I'm
motion,
here
modify
to cease
support,
and exist.
you should file such a motion.
4D. Sir, do you have a contract in dispute with me? I'm asking the court, Ms. Zorn, to place into the court all evidence she has partied on my contract. If not, I motion to dismiss with prejudice, failure to state a cause of action. This goes against my Constitution, sir. Yeah, I understand Michigan law, but it must be in compliance with the Constitution. This has violated me as a man numerous times, and now I can't even make my bill. I'm asking you to give me 50-50 split of my kids. I made them in private. I will raise them in private. There is no need in dispute, nor has there ever been. You know what, sir, underneath Article 1, Section 13, Paragraph 5, I want to face my accuser. If we could please swear Ms. Zorn in so I could face my accuser.
Transition into our second case, notice the stark contrast. This isn't a contempt hearing but a custody and child support dispute. The energy shifts, but the pattern doesn't. Another individual insisting the court has no authority over him. The clerk explains that the defendant refuses to contract with 4D workers, which is Sovereign Citizen Code 4. I don't recognize family court because it inconveniences me. But unlike the previous explosive meltdown, this defendant comes armed with rehearsed legal-sounding jargon meant to confuse, overwhelm, or derail the process. Judges see this every week. Sovereign citizens think they're revealing hidden constitutional truths, but they're actually citing irrelevant statutes, misusing legal terminology, and ignoring the basic reality: child support is a civil responsibility, not a negotiable contract.
What was the weather like at that time?
Weather that day was clear, and it was still light outside.
The road conditions?
Dry.
Okay. And you were on patrol at that time?
I was.
You were in a marked patrol car?
I was.
Where were you on patrol?
I was patrolling the downtown area near 11 Mile in Washington.
That's in the city of Royal Oak.
It is.
What what happened at that time at those crossroads?
I was stopped at the 11 Mile and Washington light facing westbound. I had a green arrow and a vehicle proceeded eastbound on 11 Mile through a light, which gained my attention. That light was red for them, which drew my attention to that vehicle.
Okay, what type of vehicle was that?
I believe it was a black 2024 Ford Edge.
Is your vehicle equipped with a dash cam?
It is.
Judge, at this time, I'd like to play that video from Officer Moran's dash cam.
Okay,
Can the court see that?
I can.
Officer Moran, you can see that video that I
I
pulled?
can. Yep.
Okay. Just playing that video now, Judge.
Okay.
Edward John Lincoln, 65011, JL 65011.
Judge, I'm just gonna stop that video here.
Okay.
If defense would like to play the rest of the video subsequently, we can. I just wanted the court and Officer Moran to see the stop.
All right.
Is that the video taken from your patrol car?
That is the vehicle for my patrol vehicle.
Does that fairly and accurately portray the events of the incident that led to the defendant being issued a civil infraction on that date and time?
It does.
Your Honor, I'd ask that that video be admitted into evidence.
All right. So admitted.
Officer, so what do you see on that video?
What I see, like I spoke to earlier, I was stopped at the 11 Mile at Washington light facing westbound. I got the green arrow to turn southbound on Washington when a vehicle proceeded eastbound through, obviously, the red light.
And then you pulled that vehicle over?
Yes, I immediately initiated a traffic stop.
And that was on 11 Mile in the city of Royal Oak?
It was, yep.
When you approached that vehicle, did you observe the driver of that vehicle?
I did.
Do you recognize the driver of that vehicle on this Zoom today?
I do.
And with that, we wrap up one of the most chaotic multi-case dockets we've seen. In the first case, Mr. Meyer went from a simple $168 issue to multiple contempt charges and potentially new criminal investigations, all because he chose insults and threats over compliance. In the second case, Mr. Smith tried to navigate family court with sovereign citizen mythology instead of legal arguments, ultimately receiving a swift denial of his custody modification. And finally, our traffic stop case shows how sovereign ideology spills over into even the simplest infractions, where video evidence often says more than the defendant ever could. These cases highlight a universal truth: courts operate on law, evidence, and procedure, not personal beliefs, threats, or pseudo-legal jargon. If you found this case as shocking as we did, hit that like button, drop your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Your support keeps this series going. And trust me, the next episode is just as wild.
Moran has identified the defendant, Anthony Mathis.
The record will so reflect.
When you pulled the defendant over, did you have a conversation with him?
I did.
And In that conversation, did he admit to you that he had driven through the red light?
He did.
And ultimately you issued him a ticket?
I did.
What was that ticket for that you had issued him?
I actually issued him an impeding traffic ticket.
Okay. But that's not what he actually did, correct?
No, that's not.
Why did you issue him an impeding traffic ticket?
Mr. Mathis at the time had a good driving record. He knew what he did. He told me he admitted to it, and he had a good attitude on the road. So I chose to go an impeding traffic ticket.
I object.
What's your objection?
I never admitted to anything. Do you guys have that on the record? Did you guys pull that up that I admitted to something?
You'll have a chance
Not,
to,
then that's false.
Mr. Mathis, you'll have a chance. Your objection's overruled. This is his testimony from his memory. You'll have a chance to testify yourself and add any additional evidence here. So at this point, that is not a proper objection. It's overruled. Anything else to add there to that?
What, just very briefly, Judge, what infraction did you actually observe?
I could have wrote him two infractions, either disobey traffic control device or disobey traffic signal.
And that's what he actually did, correct?
Correct.
Judge, I have nothing further at this time.
Now, Mr. Mathis, it's your opportunity to ask Officer Moran any questions that you feel are necessary. Now, I just want to instruct you, you'll have a chance to testify if you choose to in a moment. Right now, it's anything that you say should be in the form of a question directed at the officer. If you're going to start testifying, I'm going to have to interrupt you and redirect you. You'll have that chance in a moment. It's just to ask questions. So go ahead with any questions you have.
All right. Well, for the record, is there any injured party? Do we have a sworn affidavit or complaint from an injured party?
No, there's no injured party.
Okay, so we don't have any injured party. So Judge, you've been sworn in to uphold the Constitution, correct?
I'm not on the stand. I'm not answering any questions like that, Mr. Moran, or Mr. Mathis, excuse me.
So what type of court is this? Is this Admiralty Maritime Law?
Mr. Mathis, right now is your opportunity to ask Officer Moran any questions that you want to. If you're going to make some legal objections or something along those lines, you can do that in your closing. But right now, this moment in time is for you to ask Officer Moran any questions.
Okay, well, for the record, we don't have any